All right. Good afternoon, everyone. I hope you are having a fine Thursday and staying safe out there. Welcome to today's webinar, The Fundamentals of the FCRA, the EEOC, and Criminal Records, the Key to Compliance. My name is Megan Duncan, and I am the Event and Campaign Manager here at Validity Screening Solutions. I am joined today by our speaker, Jessica Troncoso, Director of Compliance at Validity Screening Solutions. This webinar has been approved for 1 hour of General Recertification Credit by HRCI and 1 hour of SHRM Professional Development Credit. HRCI and SHRM credit information, as well as a copy of the presentation slides, will be emailed to all eligible attendees within 24 hours. Please feel free to post any questions or comments that you may have during the webinar using the Q&A and chat section. We will try to answer all of your questions at the end of the presentation. Now, a little bit about our speaker. Jessica Troncoso is the Director of Compliance at Validity Screening Solutions. Jessica focuses on Validity's knowledge base of all laws, statutes, and enforcement actions regulating the employment screening industry. Jessica has written and presented on legal topics relating primarily to the Fair Credit Reporting Act, the FCRA. She is a member of the Professional Background Screeners Association, the Kansas City Metropolitan Bar Association, and the American Bar Association. She earned her Juris Doctor from Western Michigan University Thomas M. Cooley Law School and her Bachelor of Arts in English Literature from University of Missouri, Kansas City. All right, Jessica, over to you.
Thanks, Megan. Hey, everyone. Thanks for joining us. Welcome to today's webinar. Today, we're going to talk about the fundamentals of the FCRA, which is the Fair Credit Reporting Act, the EEOC, which is the Equal Employment Opportunity Commission, and criminal records, and hopefully establish some of those building blocks, and then how they all intersect, and hopefully get you some best practices for compliance. If I have any mishaps with these slides, bear with me, but I've got Megan here and she'll help me out. Let me see what. Okay, so before we begin, here's a legal disclaimer. I want you to read through some of it while I read through some of it out loud. I am a lawyer, but this presentation has been prepared for informational purposes only. None of this information is intended to create an attorney-client relationship, so none of this information should be construed as legal advice or a legal opinion. I'm going to take some questions throughout the presentation, but if we have time at the end for any additional questions, any questions that I answer up to that point will be based upon hypotheticals, and you are not getting legal advice or legal counsel. So with that, let's jump in. Okay, so here's our agenda for today's discussion. First, we're going to talk about the legal landscape in this area, what it looks like, what we're seeing. Then we'll talk about the Fair Credit Reporting Act. We'll spend a little bit of time on the history of the act, and then we'll jump into the key terms, the fundamentals that will hopefully help you to better understand your role. Then we're going to move on and talk about the Equal Employment Opportunity Commission's criminal history guidance and the big takeaways from that large body of literature. And lastly, we'll wrap it up and we'll talk about best practices for compliance. So this is what our landscape looks like in terms of the FCRA, the EEOC, and pre-employment screening reports. Now, in my opinion, the EEOC is pretty focused on this area of the law. I think also just taking into consideration, the state of our world. But in addition to that, the EEOC's strategic enforcement plan for fiscal years 2017 through 2021 noted that eliminating barriers in recruitment and hiring remain a top priority for the agency. Now, this can present many challenges for you as an employer, right? 2, 3, 4, sometimes upwards of 5 years of investigation, coupled with hundreds, thousands of dollars in legal cost. So litigation continues to rise in this area. Law firms all over the nation are looking for candidates. They're scouring job applications, looking for opportunities to form a class action. Now, the number of class action lawsuits has more than quadrupled this past calendar year. And to be quite honest with you, it doesn't appear to be slowing down in the years ahead, or at least in the coming year. And what it appears is happening is plaintiffs' attorneys are making this their niche practice area. So they're finding applicants and they're asking them, hey, have you been denied a job, or were you given a disclosure? Were you given an authorization? Did the job application include any kind of release language? And if that person answers yes to enough of these types of questions, then the law firm can develop a new plaintiff. So here's an example of that FCRA litigation that's on the rise. There are a few plaintiff side firms. Actually, there's more than a few. I just didn't want to muddy this slide up with every firm across the nation, but there's firms that are specializing in FCRA class actions nationwide. You can see some of those here in Florida, California, Virginia, but there's plenty of them. And in the last decade, employers have paid out in excess of $174 million to settle class action suits, claiming that they violated the FCRA in the employment screening process. Now, recent FCRA class settlements were for non-compliant disclosure statements. And we're going to get into disclosures a little bit down the way, but these can range anywhere from $63 to $300 per person, and that doesn't include fees and costs. Now, I do want to add in there additionally that there have been roughly 24 or so California state court FCRA filings since 2017, and half of those have been from mid-2019 to the present. So we're on the rise. It's got an upward trajectory. Okay, so the Fair Credit Reporting Act, the FCRA. The FCRA is federal law. It governs the collection, the assembly, and the use of consumer report information. The FCRA was enacted in 1970. It has been amended several times, most recently in September of 2018. The FCRA, it regulates the practices of consumer reporting agencies that collect and compile consumer information into consumer reports for use by end users, such as credit grantors, such as employers, a lot of your employers, landlords, and other entities in making eligibility decisions that affect consumers. Now, since its initial passage in 1970, the Federal Trade Commission, or the FTC, has played a key role in the implementation, the oversight, the enforcement, and the interpretation of the FCRA. And while the FTC retains its enforcement role, it shares that role in many respects with the Consumer Financial Protection Bureau, or the CFPB. Okay, so here are some definitions. This is our building blocks that you might want to keep in mind as you navigate the FCRA or you think about the role you play. Let's start here with consumer report. That's a report or a document that contains one or more of the following pieces of information about an individual. So it could contain credit standing, credit history, personal characteristics, character, general reputation, mode of living. Now, this information is primarily provided through employment verification, references, education verification, licensure, as well as criminal, motor vehicle, and credit report records. Now, consumer reports are often referred to as background investigations or background checks or screening reports. The consumer report is the legal term of art, but they're referred to as background checks. Consumer Reporting Agency, a CRA, that's a business that assembles information on individuals at the request of a third party, that third party being their client, which is often an employer, often a landlord. Validity Screening Solutions, we are a CRA, so we're a Consumer Reporting Agency. Now, any report that contains any of that information I just read to you is defined only as a consumer report when it's compiled by a consumer reporting agency. The next definition, end user, that's an entity, that's an employer, that's a landlord that requests a consumer report from a CRA for a permissible purpose. You got to have a purpose to pull that report. Now, that permissible purpose, those are the instances which the FTC has outlined in the Fair Credit Reporting Act that they've deemed acceptable for an end user to obtain a consumer report. There's an enumerated list contained within the FCRA. A couple of them, you see court order, subpoena, child support enforcement, insurance, but the ones most commonly, the common types are employment and tenancy. And then lastly, adverse action related to employment. This is a two-step process. We're going to go through this process down the way that an employer is required to follow anytime the employer intends to make an adverse decision with respect to the individual's employment. If that decision is based in whole or in part on information contained in the consumer report. So you get information in that report, you're going to make an adverse decision, adverse actions, the process you're going to follow. Okay, so that's the FCRA. Now we're going to move on to the EEOC. So in April of 2012, the EEOC released consolidated guidance on the use of arrest and conviction records. Now, one of the main focuses of the EEOC, not only in what we've seen in its litigation, but also in this criminal history guidance, is that they believe that an employer's use of both criminal history and credit history have a disparate impact or a disproportionate impact on certain minority groups, specifically Hispanic individuals, African-American individuals, and men. Now, this guidance explained how an employer's use of criminal history may violate federal anti-discrimination laws, specifically Title VII of the Civil Rights Act of 1964, which bars discrimination on the basis of race, color, and other protected factors. Now, the 2012 guidance is not binding on employers, right? It's guidance. So it doesn't have the same full force and effect of the law, but instead it was designed to be a resource about how to assess criminal history in line with Title VII standards. Now, this includes considering the nature of the person's offense, how much time has passed since that offense, and whether that offense is related to the job that they're seeking. We got a quick question here from Joanne. Is the EEOC guidance available to the public? Joanne, the guidance is available to the public. It's on their webpage. I believe it's eeoc.gov. Somewhere on there is like a section that says laws, regulations, guidance, sorted according to like subject matter. So you should be able to find it there. I do encourage you to give it a read. Maybe in chunks, take some time to digest the material. It's lengthy, but it's informative. Okay, so some items of note. We're going to hit the highlights out of the EEOC guidance. Our employers cannot make hiring decisions based on protected classes. So a person's race, a person's origin, a person's gender, their disability status. Information from any source cannot be used to discriminate in violation of federal laws, right? You want to apply the same standards for everyone. You want to consider every applicant on a case-by-case basis. Now, the EEOC strongly discourages the use of arrest records because the fact that an individual was arrested is not proof that he engaged in criminal conduct, right? So therefore, an individual's arrest record standing alone may not be used by an employer to take a negative employment action, such as not hiring that person or firing them or suspending that applicant or that employee. The FCRA, the federal law, it prohibits the use of arrest records. Okay, another item of note from that EEOC guidance is disparate treatment versus disparate impact. Now, an employer may be found liable for violating Title VII when an applicant can demonstrate that the employer treated him differently, him or her differently, because of their race, because of their national origin, or another protected basis. Now, for example, say you have an employer who rejected an African-American applicant based on his criminal record, but hired a similarly situated white applicant with a comparable criminal record. So let's say you have a fact pattern that's, you have an individual named John. John is a white male, and then you have Keith. Keith is an African-American man. Now, both are recent graduates of the local university, and they have similar educational backgrounds. They have similar skills. They have similar work experience. But they each pled guilty to charges of possessing and distributing marijuana as high school students, and neither of them have had any contact with the criminal justice system since that time. So after college, they both apply for employment with a local company, and that local company has some short intake interviews and then obtains their consent to conduct a background check. So based on the outcome of those background checks, which revealed each of their drug convictions, that company, a representative from that company, decides not to refer Keith. Who's Keith? Keith is the African-American man. They decide not to refer him for a follow-up interview. And that representative was found having made remarks to a coworker that Company A cannot afford to refer or to hire these drug dealer types or refer them to client companies. However, that same representative refers John for an interview and asserts that, well, John's youth, at the time of his conviction and his later lack of contact with the criminal justice system make the conviction unimportant. So what that company has done, we'll call Company A, they've treated John and Keith differently based on race in violation of Title VII. Now, the EEOC noted in this guidance that Title VII prohibits not only decisions driven by racial or ethnic animosity, but also decisions infected by stereotyped thinking. So an employer's decision to reject a job applicant based on racial or ethnic stereotypes about criminality, rather than on their qualifications, rather than their suitability for the position, is unlawful, disparate treatment that violates Title VII. Now, disparate impact, on the other hand, is when an employer may be liable for violating Title VII when an applicant demonstrates that the employer's neutral policy or practice, so on its face, it appears neutral, but it has the effect of disproportionately screening out a Title VII protected group, and the employer fails to demonstrate that the policy or the practice is job related for the position in question and consistent with business necessity. So an example of this, a practical example would be when an employer excludes all persons with convictions, they exclude them all, in certain categories of crimes, regardless of the age of the conviction or whether the conviction was a misdemeanor or felony. Blanket exclusions. That would be disparate impact. Okay, so the EEOC guidance, they offered 3 factors that you want to consider in terms of job relatedness and business necessity. Now, the 8th Circuit, which covers Missouri, identified these 3 factors called the Green factors from a 1975 decision in Green versus Missouri Pacific Railroad that were relevant to assessing whether an exclusion is job related for the position in question and consistent with business necessity. So that first factor there is the nature and gravity of the offense or conduct. Well, let's unpack a little bit about what this means. This means you want to look at the offense or the conduct and you want to ask yourself, is it a felony? Is it a misdemeanor? Is it an infraction, an ordinance violation? Is it some type of crime against a person or property? You know, who was the injured party here? And then those answers are what you will consider when determining whether or not the conviction is truly job related for the position the applicant is applying. The next factor is the time that has passed since the offense or conduct and or completion of the sentence. That's pretty self-explanatory. Do you have an applicant before you that has an offense or some sort of conduct from their past when they were 21 and now they're 42 and there's been no contact with the system since that time? How long has it been? And then that third factor is the nature of the job held or sought. And what this means is, what are the essential job functions? So let's say you have someone with a DUI conviction, driving under the influence, and the essential job function that they're applying for, the job you're going to have them do is driving, right? That conviction may be more job related because this person drives. And there's a number of illustrations that you can come up with. But the EEOC recommends considering these 3 factors when you're reviewing criminal records, when you're reviewing the offenses and the conduct. Okay, the EEOC also had this suggested tool for accomplishing this assessment. It's something that's been coined the decision matrix. It's a table, it's a tool that would help you apply a consistent standard for screening applicants and employees and applies the same standards to everyone. Now, this could help you avoid a practice of denying all of those with convictions. The decision matrix would detail which offenses are acceptable and which require review. So if you look at that there, across the top, the x-axis, you have different types of positions at your organization, right? So you have leadership, directors, general employees, managers, so on and so forth. And on the y-axis down the side, you have different types of crimes. You know, we have them categorized crimes against persons, crimes against property, so on and so forth. So you will use this tool to help you be consistent with the types of criminal records that you learn of and what you do with those results. And a green category, you see that key up there, pass or acceptable with a green box. A green category is used for those offenses that are a pass or acceptable for something that maybe you find no criminal record for. And a yellow category is used for those offenses that need review. Now, since each offense needs to be considered on a case-by-case basis, it's important to never have an automatic rejection or a red category in your decision matrix, right? Now, I think there's some organizations out there that there's exceptions to this rule. For instance, you know, if your organization is regulated by some sort of some federal law that requires certain exclusions. For example, maybe the FDIC in banking, those laws may supersede the EEOC guidance. And for state laws that conflict with this EEOC guidance, we would recommend that you consult your in-house or independent legal counsel. I will tell you this too on this decision matrix. If you haven't already created one, after this, if you want to send me an email or give me a call, I can get a sample to you. We have a sample matrix created, so you don't have to do a lot of the heavy lifting's already been done. Okay, so for those of you that have not run across an individual with a criminal background or any sort of derogatory information, everything we've talked about up to this point and everything we'll continue to talk about will relate to information that you receive in your background screening report, right? Be it some sort of criminal record or some sort of derogatory information. So let's talk about some of these steps to help keep you compliant, to be sure you're compliant. Okay, step one, policy. I cannot say this, impress upon you this policies are so important. The first thing you should have is an employment screening policy, right? Before starting the background screening process, it's crucial that you create a policy that outlines the purpose and the scope of your program, right? With that being said, always consult legal counsel before implementing a new employment screening policy. And obviously we recommend consulting an attorney that's well-versed in the Fair Credit Reporting Act and or labor employment law. But with policies, consistency is key, right? Having a documented policy brings consistency across the board. You'll be able to lean on your policy. You'll be able to say, we did the same thing at the same time for everyone. That policy, you wanted to establish the who, the what, the when, the where, and the why, right? You want to get all that information contained in that policy and maybe try to answer some of the following questions, like, why do you need to run a background check on applicants or employees? Why do you need to run it? Who will have a background check run on them and how often? So are you going to only run them pre-employment? Are you going to run after a year? Are you going to put everybody through a system again and run them again? What types of background checks will you run? Are you just going to look for criminal county records? Are you just going to request employment verification or credit history? Maybe they're, money handling. How will the information be used? Like, how will this affect employment opportunities? Are you going to use a third party to perform these background checks? If so, what agency are you going to use? How are you going to handle disputes? And how are you going to verify the accuracy of information in a report? So you just want to, ask these thought-provoking questions and then get those contained within that policy. It's also highly recommended that if you are updating your policy, that you include some language in there that says, in accordance with the EEOC's recommended guidance, we do not discriminate based upon these protected classes. Why? Well, reason for that is maybe if one of your candidates or employees file a grievance with the EEOC based on their background check, you can at least maybe rest a little easier since you have taken their guidance into consideration, right? You've demonstrated that. You also want to list the compliance steps for following the FCRA and develop that decision matrix. Okay, so there are many compliance steps. And when we at Validity, when we talk about compliance, we talk about it in terms of compliance with the FCRA, right? So you'll see the steps here. The initial notice is a best practice only. It's not an FCRA mandate. The initial notice can be a statement in a job board or recruiting tools, but it lets your applicants know that your organization conducts background checks. It can be a sign outside of human resources, or it can be a letter given to applicants' employees. And then the disclosure and authorization. The disclosure and authorization documents must be given to an applicant or an employee before a background check is initiated, right? It's not enough to tell the applicant that your organization runs background checks. You can't just tell them, and you have to give them the disclosure and authorization. You have to give it to them beforehand. Understanding these obligations under the FCRA is very critical. I really cannot impress upon you enough how important this area is. Now, the disclosure document discloses to the prospective employee or the employee that you intend to get a consumer report, right? And the disclosure and authorization is one of the most common areas of class action litigation. Now, this is because the FCRA has very specific hyper-technical requirements on how the disclosure and authorization are supposed to be presented, right? And the purpose of that disclosure and authorization are to ensure that the applicant or the employee understands that they will have a background check run on them as a condition for employment or as a condition for promotion or assignment. Now, the disclosure and authorization should be standalone documents, meaning one disclosure or one authorization, separate sheets of paper. The disclosure and the authorization should not include a release of liability statement, nor should there be a release of liability statement that applies to the background screening process anywhere on the job application, right? You want to remember that extra language only detracts from the message of these documents. You want these documents to be clear, concise, basic. If you have additional waivers, if you have additional authorizations, fine, do it in a separate document. Also ensure that you include the following supplementary document with the disclosure and authorization. That's a summary of your rights under the Fair Credit Reporting Act. That summary is a pre-written document by the FTC. It can be electronic, it can be a hard copy, but it details their rights. And then certain states have specific disclosures that must be given to the applicant in addition to the standard disclosure and authorization documents. So as an employer, you should provide these documents if your organization or your applicant is located in one of these states. I got a quick question here from Michelle. Does the FTC have a disclosure and authorization form that I can print and use for my background checks? Michelle, I wish. No, the short answer is no. Unfortunately, they do not. The FTC nor the CFPB have no model disclosure and authorization forms. They prescribe, I say that with air quotes, they prescribe what these should look like in the FCRA, right, in the law, but this is left to the courts to decide what those should look like. And yes, it's often a challenge to be compliant with the FCRA. The law asks us to keep it simple and straightforward, but the law is not straightforward and it's not perfect. So maybe down the road, but no, as of now, no. Okay, so now you're ready to make the hiring decision. Okay, so this now assumes that you have gone through that first process of implementing a policy and decision matrix, right? You want to be sure that everyone involved or everyone in that hiring decision clearly understands what your company policy is before you make any hiring decisions. And most importantly, you want to understand the data that's being presented to you. So you'll want to understand the difference between a felony and a misdemeanor, right? So Validity, for instance, provides all reportable misdemeanors and felonies. You want to know the disposition. That's generally what happened in the case, the outcome, whether the individual was found guilty or not guilty. Now with this, you're only allowed to have two different types of criminal case classifications: convictions and pending cases. You're never in an employment screening realm, or if you're in a volunteer screening realm, allowed to know about arrest, dismissed cases, or acquittals. They are a part of the public record, but not a part of the record that you, the employer, are allowed to use. Defendant ID, we provide you at Validity, we provide you with a positively identified individual. And sometimes you'll get a report that says clear, and maybe you've had what we'd like to call an overly honest applicant sitting before you that's told you something from their past, right? Well, the reason for this is that there are some criminal offenses in jurisdictions that can be removed from the criminal record after a certain period of time, right? So in Kansas, I believe there's diversion, and in Missouri, there's suspended imposition of sentence. Now, what that basically means is, an individual, generally a first-time offender, rarely someone with multiple offenses, that defendant can make a plea deal that will get them probation for X number of months in exchange for doing certain things. Community service, substance abuse awareness programs, victim impact panel, so on and so forth. And so at the end of that period, that defendant goes back before a judge. And if the judge determines that the defendant met all of their requirements, right, they crossed all their T's and dotted all their I's, and that judge can strike the case from the record permanently, right? It won't be available to be found. So here's some tangible reasons why you as an employer should care about this. There are damages. These are the damages that are available under Title VII and the FCRA. And should you find yourself defending a claim, this is what you could be looking at. Back pay, pre and post judgment interest, compensatory and punitive damages, oftentimes left to the discretion of the jury, right? And statutory limits according to, what size of an employer are you? The bigger the employer, the bigger the fine. And then, attorney's fees, often, no limit. So these are some of the reasons why you should take this seriously. Now you're at decision time. You have a report on your desk, and it raises the question, could a criminal record in this applicant's background check prevent him or her from being hired? Well, a couple of things that you absolutely must do. This is another area that companies get sued on frequently, and they frequently lose. So if you have a situation where you find a criminal record for an applicant where you are now going to put through an individualized assessment, you must issue your candidate what is referred to as pre-adverse action. Remember, we talked about that two-step adverse action process. It's the first part of that. And what this letter basically says, it says something along the lines of, dear candidate, we found something in your background check. We are considering taking action, right? You haven't taken the action yet, pre-adverse action. But we're going to have to review it based on your company policy, on our company policy, and we'll get back to you. You give them that letter, you give them a copy of the report, you give them a copy of the summary of rights document. Pre-adverse action, this is not an optional step, right? It doesn't necessarily mean that you are going to exclude that candidate. It doesn't mean that, but it means that you're putting them on notice that you may find something that may be exclusionary. And you're also allowing them a time to remedy the situation. Some employers, they take an ultra conservative approach to this, and they send this letter out to every applicant that they run a report on. So that's some food for thought. Now, in a handful of states, there are a couple of different documents that you must provide in addition to the pre-adverse action process. You'll see these listed here. New York's got that Article 23A of New York Correctional Law. You'll see in New Jersey and Washington, some of the states have their own state-specific FCRA. It's just state-specific. It oftentimes mirrors the federal law, but you have to give that a copy of those rights under that state law. And in Massachusetts, you got to give a copy of the background check policy. So after this wraps up, hopefully all of you are going back to your home office after you set a load of laundry maybe, and coming up with the background check policy. Okay, so why pre-adverse action? Why it's important? Well, false positives are one of the reasons why it's important. other than it being mandatory, according to the FCRA, is that there could be instances where the court record is inaccurate, right? There could be clerical errors, human errors. We're all capable of them. Expunged records that shouldn't be in the public record. But either way, this gives the candidate the opportunity to call you back or to call us if we were your agency and explain that this shouldn't be on their report for, X, Y, and Z reason, and they want us to reinvestigate. We as a CRA, we're required under the FCRA to reinvestigate. Okay, so we just came out of pre-adverse action. It's a two-step process. Now you've got a waiting period. The waiting period is just part of it, but it's really only a two-step process because it's pre-adverse and adverse. But between pre-adverse and adverse, you've got a waiting period. Now, the FCRA does not define the waiting period, and they instead say that you must wait a reasonable period after sending the pre-adverse action notice before taking the adverse action, right? Reasonable. So reasonable can be defined differently for all of us. But what I can tell you is that you should not send out, and don't laugh at me, but we've seen folks that do this. You should not send out the pre-adverse action and the next step, which is the adverse action, in the same envelope, right? You've got a waiting period there. We have validity. We recommend 5 business days, even if you know what your next step is going to be. Wait the 5 business days. I've got a question here from Daniel. Daniel, what are you saying? I already know that I am not going to hire my applicant, and I have sent pre-adverse action. Can I go ahead and send adverse action and move on? Or do I need to wait 5 days? Yeah, Daniel. So again, the FCRA is silent on the waiting time between pre-adverse and adverse. They say reasonable. You got to be reasonable before sending the adverse action notice. The FTC, the Federal Trade Commission's interpretation of the FCRA suggest a minimum waiting period of 5 business days. So validity recommends at a minimum 5 business days before pre-adverse and adverse. And that waiting period, Daniel, that allows consumers an opportunity to identify errors, right? To identify inaccuracies and otherwise respond to the information that's contained in that report. Good question, Daniel. Okay, so then that next step of that 2-step adverse action is adverse action. It's the last step in the FCRA process that when you know good and well that you are not going to hire someone because they didn't meet the expectations of your individualized assessment. So for example, you had that person with a DUI conviction, and the job that they were going to be doing was driving, or you had an embezzlement conviction for a payroll clerk. You're now going to issue the adverse action letter. Now, the significant difference here is that the pre-adverse action letter lets your candidate know that we may have found something we don't like, but we're reviewing it and we'll get back to you. The adverse action lets your candidate know, hey, we found something, we can't move forward with the offer, we rescind the offer, and then it tells them who put the report together, right? Because you have to tell these folks, you have to tell them who put the report together so that if they have any questions or problems, that they know who to contact. Otherwise, you're leading them down a road where they don't know where to turn. You also have to provide a copy of the consumer report with that letter, and you have to provide the summary of your rights document. But when you issue the adverse action letter, you can then move forward, and close that file, so to speak. You don't have to wait for anything to come back. I've got another question here, Brenda, if I sent the summary of rights document with the pre-adverse action notice, do I need to send it again with the adverse action notice? Brenda, the short answer is yes. Yes, you do. The FCRA mandates that at both steps, right, pre-adverse and adverse, that you send a copy of the summary of the rights document. Okay, lastly, some administrative requirements that are important to take into consideration for all policies. Data retention and disposal. FACTA, which is another large body of federal law, which we do not have time to get into today. It's the Fair and Accurate Credit Transactions Act. It dictates that there is a statute of limitations for FCRA compliance documentation of 5 years. Meaning that applicants have 5 years to bring an action against you if they believe they were wronged. So you want to maintain your documents for 5 years. You also want to consider maintaining all background related documents separate from your personnel files. Now, this is just more for EEOC reasons, to avoid any hint of, a discriminatory hiring practice. Record disposal, it also needs to be done securely. I think shredding, they say incinerating, securely dispose of the data. So here are some resources. I know I'm a fast talker, but you can always call me or email me or find me on LinkedIn. I'm here for you. Here's some resources though that we have. And I'm sure we have plenty more. The Companion Guide to Compliant Background Screening Practices goes over in depth a lot of what we talked about today. You can read it at your leisure. Also those sample background check policies. And in 2021, just right around the corner, validity screenings will be announcing and introducing our knowledge base. It's gonna be a really incredible, awesome tool that's gonna be right at your fingertips. So look forward to that. Megan, I think I have a couple other questions here. Let me see. Is it okay to use an older version of the summary of rights document? Yeah, good question. I didn't answer that. I don't think I covered that. So hypothetically speaking, right, since we're hypothetically speaking here, that may put you at risk for non-compliance because back in September, late September 21st or so of 2018, there was a Senate bill that was enacted that amended the FCRA to allow consumers to request a security freeze that was free of charge from the nationwide credit reporting agencies. So, Equifax, TransUnion, Experian. Now, that it also extended the length of time for initial fraud alerts from 90 days to 1 year. So both documents, there's a summary of your rights under the Fair Credit Reporting Act, and that there's a document remedying the effects of identity theft. Those have been changed to notify consumers of those expansions. So when you're sending out those summary of rights documents, double check your CRA to make sure they're sending out the most current version, right? Because if you're using a non-compliant version and you're leaning on your CRA and you're thinking, oh well, they got it covered, that may be so, but it also may not be the case. So that's pretty important. I checked that one out. And then here's another question. Our company performs drug tests on prospective employees and current employees. Do we have to follow the FCRA? Okay, well, it depends. The actual FCRA is silent on the matter, Leslie. That was a question from Leslie. However, the FTC, that's the agency that enforces the FCRA. They have a 2011 staff report, and they noted in that report that drug test results provided by a lab directly to an employer are not consumer reports because they constitute reports based on the experience of the lab with the consumer. So our recommendation, with all of the research that we've done and according to what we see for industry best practices, is that it's likely that the drug test will be considered a consumer report if the lab provides that report to the CRA, and the CRA in turn includes that in the consumer report. So say you're the employer and I'm your CRA, and you've got Bob in front of you. We performed a drug test, and that report's going to come from the lab to me, Validity, the CRA, and then I'm going to put it in the report that gets dispatched to you. Yes, follow the FCRA. But if it goes from the lab to you, the FTC has said, it's not a consumer report. So that's the long and the short of that. Here, Mary, is it okay to add a release of liability at the bottom of the disclosure or authorization if I change the font and insert spacing between the signature block and the liability release, Mary? The disclosure document, it discloses to the prospective employee that you intend to get a consumer report, right? And according to the FCRA and the FTC, their interpretation of the FCRA, along with voluminous case law, the disclosure and the authorization should be standalone and separate from any other documentation, right? Hypothetically speaking, again, including any kind of language that claims to release you from liability for conducting, obtaining, or using the background screening report may put you at risk for non-compliance with the FCRA, right? Because that extra stuff, that extra language, it not only makes it harder for the prospective employee to understand the main purpose of the document, the intent, but it also may violate the FCRA, right? Adding any sort of other acknowledgements or releases of liability is beyond the scope of what the FCRA permits in this document. So, Mary, hypothetically speaking, if you have additional waivers, if you have additional authorizations or disclosures that you want to give prospective employees, do it in a separate document. Do not include them in the FCRA disclosure and authorization document. And let me see. Melissa, I do have samples of the pre-adverse and the adverse action letters. I can send you a link. We can talk about it on the phone, or you can send me an email. I think Megan's going to flash my contact info after this. And then, I can get it to you really easily. No problem. And I think that's it.
All right. Thank you, Jessica. And thank you everyone for attending today's webinar. On behalf of all of us here at Validity, we thank you again. Again, you can email Jessica or I if you have any remaining questions, and we'll be sure to get those answered. SHRM and HRCI, they are also offering credit for recorded webinars. So if you want to hop on our website, you can see it right under her LinkedIn. You can go to our upcoming webinars tab and go to on-demand webinars and watch recording webinars to get credit from past webinars that we've done. So feel free to do that and tell your friends or tell your colleagues. And thank you again for joining us today, and have a wonderful rest of your Thursday.